Good afternoon and welcome to the new Civil Liberties Alliance. My name is Richard Samp. I am a senior litigation counsel here at NCLA. And today we are very honored to have several guests who are perhaps the authors of two of the Securities and Exchange Commission's largest defeats in court in the last year. And they're going to be talking today as part of our Luncheon Law program, which is entitled, Caught with a Hand in the Cookie Jar, Can We Hold SEC Accountable for Its Shenanigans? First of all, to my left, I have one of my colleagues here at NCLA, Peggy Little. She is also a senior litigation counsel with decades of experience as a trial and appellate lawyer. Most relevant for today's discussion, Peggy was lead counsel in SEC versus Cochran, where NCLA recently won in the Supreme Court a major victory over the SEC. We also have here via camera S. Michael McCulloch. Mike is a veteran litigator with 35 years of experience handling business and commercial litigation before just about every state and federal court you can think of. And most relevant to our discussion today, Mike just this past week argued in the Supreme Court in a case by the name of SEC versus Jarkesy. He won a major victory against SEC earlier in the year before the U.S. Court of Appeals in New Orleans, and the SEC, I'm happy with that decision, brought its case before the Supreme Court, and that was why last week's oral argument. We'll also in a moment have Mike's co-counsel in that case, Karen Cook. Karen has 2 decades of experience in securities litigation, regulation, and enforcement. As part of that experience, she served for 10 years as an SEC enforcement attorney, last serving as assistant director of enforcement. So when we talk about SEC shenanigans, I think you can rightly say that Karen has a lot of firsthand experience. Now, I'd like to begin today's discussion with perhaps a discussion of a mystery that perhaps some of our panelists can help us with. The SEC, until recently, had quite a few enforcement actions going on administratively, but instead, somewhat mysteriously, it dismissed 42 of those cases, including the case involving Michelle Cochran, one of Peggy's clients. When Peggy won her victory, what it allowed her to do was to go into court and fight directly against SEC, but for some unknown reasons, the SEC dismissed that case. As a matter of fact, the only case it didn't dismiss was the Jarkesy case, in which it had lost, as I mentioned, a major decision in the Court of Appeals. And it took that case to the Supreme Court rather than dismissing it. So, Peggy, perhaps you can begin the discussion by explaining to us, why is it that do you think that the SEC dismissed your case, and what's going on here?
Well, the timing is revealing because just weeks after the victory we had in the Axon Cochran case, which allowed people who wanted to raise constitutional claims with administrative adjudication, they could go directly to district court and raise those claims. And just weeks later, boom, a list of 42 cases, all of the open cases before the SEC are dismissed, with Michelle Cochran's case at the top of that list. The pretext given by the SEC for that dismissal is also troubling, because while Michelle Cochran's case was pending in the Supreme Court, and also while George Jarkesy's case was pending in the Fifth Circuit Court of Appeals before the favorable decision in his case, the SEC filed something called Notice of Control Deficiency, in which it revealed that enforcement staff had accessed the files of the administrative law judges in the SEC administrative proceedings. That's deeply troubling. It made a big splash in the Wall Street Journal at the time. The SEC denied that there was any real problem, but it also failed to disclose any facts, any investigation, even though it claimed the detailed investigation involved dozens of interviews and looking into the situation, but there was no real harm. Being no fools, we filed FOIA requests immediately, as did counsel for Jarkesy, and that turned out to be completely fruitless. The SEC gave us nothing in the FOIA proceedings. Both of us took them to court. NCLA took them to court in the District of Columbia.
Let me interrupt you here for a second. Maybe Mike can jump in and explain to our listeners a little bit more about what a control deficiency is. I understand that the SEC has, on the one hand, people they call administrative law judges, ALJs, who are the trial judges who are supposed to be deciding disputes between the SEC enforcement staff and people such as your client. And they pretend that there is somehow this wall between them, and that when the ALJ is deciding something, they're not supposed to be sharing information with the enforcement staff, so that there is no real advantage given to the prosecutors in the case. The prosecutors generally don't talk with judges. And Mike, maybe you can tell us a little bit more about what a control deficiency is and how that worked in your particular case with your client, who before he won his court victory was relegated to an enforcement proceeding in front of the SEC.
Certainly the so-called control deficiency, really an Orwellian label for it, falls very much under the definition of shenanigans, the title of this webinar. So for perspective, as you've just been laying out, what the structure internally for these administrative trials, these administrative adjudications, is that a case is tried, quote unquote, before an administrative law judge, an ALJ, and then because in the SEC at least, a respondent, who is the defendant in the proceeding, loses 100% of the time, or virtually there. So you appeal to the commission from the ALJ. So the commission not only plays the role of the grand jury and issues the initial accusation, they then act as the appellate court from an adverse judgment by the ALJ. And so it's important, if that process is going to have any legitimacy at all from a due process standpoint and a fundamental fairness standpoint, for the enforcement staff that prosecuted the case before the ALJ to be completely separate from the commission, which is now acting as an appellate court. And what turned out to be happening was apparently for years on end, the enforcement staff was hacking into the commission's decisional database, where the internal communications, memoranda, proposed orders, et cetera, were being developed internally at the commission level. It's the equivalent of an assistant U.S. attorney hacking into a D.C. Circuit or Fifth Circuit's database while an appeal is pending to try to get information on what's going on with the appeal. So the SEC identified that, did not announce publicly, did not take it straight to the Inspector General. The commission instead initiated its own internal in-house investigation, finding that on a number of occasions, especially with regard to the Jarkesy and the Cochran cases, enforcement staff had hacked into the database of the commission. and the general.
That sounds pretty nefarious to me. So I assume that the SEC would have said, gee, that wasn't very fair to Mr. Jarkesy. He's entitled to a new hearing in front of a new ALJ because of this misconduct. Is that what they did?
They did not do that. They sat on it. They waited until the case was well up on appeal to where there was really nothing that could be kind of done about it. They controlled the flow of information. They did their own in-house investigation led by the general counsel's office at the SEC, so they could then claim a work product protection over the investigation. By contrast, what a federal agency is supposed to do when there's some significant internal misconduct is refer the matter to the inspector general for each agency to conduct an independent investigation. And there's a lot of power that the inspectors general have to obtain email communications, grab people's computers, phones, conduct witness interviews. But what happened here was that the commission concocted its own internal in-house investigation, which allowed them to control the information, the evidence, and then hide it from us, and which is what they did.
Now, I understand that you objected, and you have been objecting all along, to the fact that the SEC was having an administrative tribunal that denied you a Seventh Amendment right to have a jury decide the facts of this case. So while this nefarious activity was going on, did you make any effort to try to go into federal court and ask the federal courts to decide whether it was proper to the SEC to be denying you these jury trial rights?
Well, so I think there's two parts to that question. Did we ever go to court to deal with the hacking that was ongoing while the case was going on and while the appeal was going on to the Fifth Circuit and then the Supreme Court? And the answer is we did not do that because it had already all happened and supposedly was over and was being investigated internally at that point. So the case was, they waited until the case was too far along for us to do anything about it. We did.
Actually, I was trying to pivot to the other issue of the fact that your Seventh Amendment rights were in jeopardy by these proceedings. How long did those proceedings go on? How many years did that take place?
About a decade, certainly about 8 years inside the commission. So the investigation began in 2011. They filed their order instituting proceedings, which is the equivalent of a complaint administratively, in 2013. We went to trial in 2014. Right before the trial, we filed a lawsuit in U.S. District Court in the District of Columbia District, and tried to enjoin the proceedings on multiple grounds, including the Seventh Amendment, that Mr. Jarkesy was going to be denied his jury trial rights. And
did the D.C. Circuit allow you to raise those issues on the merits and decide about your Seventh Amendment rights?
The district court, followed by the D.C. Circuit, refused to allow us to proceed with that complaint, with that lawsuit, denied the injunction, and did so on exhaustion of remedies grounds, saying that we had to go through the entire, what turned out to be more or less decade-long administrative process before we could ever reach an Article III court for redress, which is what ended up happening. Of course, the Cochran case.
Right, and that was actually what I was just going to ask Peggy about. So that sounds like not much of a remedy at all if you have to sit through 10 years of administrative proceedings before you can even raise the issue of whether they're denying you your constitutional rights. So Peggy, why don't you tell us about your Cochran case, where I think you tried to address that issue of being able to go straight into court?
Correct. Jarkesy's counsel filed one of the first cases and they lost in the DC Circuit. By the time NCLA took on this battle, there were 5 circuits that held that you had to undergo the administrative proceeding before you could challenge its constitutionality, which actually makes no sense if you think about it. We were fortunate in Michelle's case in the Fifth Circuit to get a stay of her administrative proceedings pending a decision by the Fifth Circuit. Even there, we lost at the panel stage 2-1, where they kind of followed on with the other 5 circuits that had held this and said, no, she still has to go through the proceeding. Thank goodness. And with your help, Rich, we got en banc review of that panel decision, and the full Fifth Circuit Court of Appeals issued really a stunning decision, well worth reading. But the holding of that was that she did not have to go through the unconstitutional proceedings before she could challenge the constitutionality.
So I gather the Supreme Court needed to address the fact that there were conflicting decisions now from Court of Appeals. So what happened then?
You created the circuit split and went up to the United States Supreme Court. And delightfully, it was a unanimous decision that said this makes no sense, that you have to undergo an unconstitutional proceeding before you can challenge its constitutionality. And Justice Kagan was really quite emphatic about it. It was a very short decision. She said, there's a timing problem here. If you want to challenge the constitutionality of these proceedings and then you have to undergo them, the harm has already been done, which is what we had been arguing all along. So that's U.S. Supreme Court unanimous decision overruled and or in the case of Axon reversed 6 circuit courts of appeals that had gotten this wrong for close to 10 years.
Well, unfortunately, that error was the error correction came a little bit too late to help out Mr. Jarkesy. He had to go through this entire decade. As it always does, the SEC ruled in favor of itself, and Mr. Jarkesy then had to bring his case into the federal appeals court in New Orleans, and we now have Karen Cook on the line, and so Karen, perhaps you can tell us a little bit about the issues that you raised in the Fifth Circuit to try to overturn the SEC's decision.
Thank you. We raised 5 issues. 3 of them are related. The Seventh Amendment right to a jury trial, the non-delegation issue, which relates to the SEC's discretion that Congress gave to the commission to decide where it wanted to bring, which forum, either the Article I court or a federal court, and then also an equal protection claim. Mr. Jarkesy had been relegated to an administrative proceeding, while other defendants and respondents with very similar circumstances, facts, and charges were allowed to go to federal court where they had full constitutional rights. And so those 3 issues are related, and we brought them together. We also raised the administrative law judge issue because it had been fleshed out in the Lucia case that they have multiple layers of tenure protection, which is under free enterprise. That's too many layers. And then number 2, the 5th issue was a prejudgment issue. This falls into the category of shenanigans. When the SEC brought its case against Mr. Jarkesy and his company, they also included another individual in his company. That individual and his company decided to settle the claims. And at the time they did that, the commission issued an order that included finding against that individual and his company, and also included findings against Mr. Jarkesy and his company, including that they had violated the 1940 Act and the anti-fraud provisions. Okay, well, all this occurred before his trial ever took place. And so that was an issue we raised with the Fifth Circuit of prejudgment.
Now, just to move things forward, you won a unanimous decision in the Fifth Circuit. The SEC said the sky was falling, and it asked the Supreme Court to review the case, which it did last week in its oral arguments. So my question to both Mike and to Karen is the sky falling? Is the ability to enforce the securities law going to be totally undercut if the Supreme Court agrees with the Fifth Circuit that these proceedings that the SEC conducted were a serious violation of your client's constitutional rights?
Well,
I guess I would. Oh, go ahead, Mike.
Swing at that first. The government, the SEC, raised this apocalyptic straw man issue from the beginning, and certainly pounded it hard during oral arguments at the Supreme Court. The fact of the matter is, a ruling, the Fifth Circuit's ruling, and any ruling by the Supreme Court in favor of Mr. Jarkesy on the Seventh Amendment issue will not have a great impact, at least on the SEC, for a couple of reasons. One is the Seventh Amendment applies to any claims that are common law claims, meaning for legal relief, as in penalties or damages, and of the sorts of claims that were tried in the courts of England in the 18th century. That's been the Supreme Court's rule for 200 years, and there are reasons why that's the measuring stick. And so we're only talking about a very small subset of the total amount of matters that ALJs at the SEC hear. And it's mostly fraud cases, traditional fraud actions. And so the other reason it won't have a great impact is that seeing the handwriting on the wall, the SEC over the last few years has been returning its securities fraud cases, those enforcement actions, to federal court and not attempting to litigate them in their own in-house courts, to the point, as we pointed out to the Supreme Court last week, there aren't any pending cases right now of fraud type cases under 10b-5 that are pending in the administrative courts. So the actual impact on the SEC, were they to rule in favor of Jarkesy along the lines of what the Fifth Amendment held, will be exactly zero. It won't impact them at all. Now, will it impact other agencies? That's another question. But the SEC, somewhat to its credit, has seen this problem on the horizon and has already moved its cases back to federal court, where they all belonged in the first place.
And Karen, I'd like to have you discuss how you think the oral arguments went in front of the Supreme Court. If you had to guess, what do you think they're going to do?
Well, I think the argument went well. The justices were all engaged. They all asked challenging questions, both of the Solicitor General and of us. I would say you can never predict what any court is going to do, including from the oral argument. But we do remain hopeful that they will. We remain hopeful they will find for Mr. Jarkesy on all three issues. But we're in looking what commentators think, to the extent that's predictive. It seems like many think that the court at least is open to the Seventh Amendment issue.
That was my impression, that almost the entire argument was devoted to the Seventh Amendment. Is it possible that the other issues, the one that you described, the non-delegation doctrine, and the other one you described was the fact that the president's authority to control administrative law judges has been restricted because of the double layer of tenure protection given to these ALJs? Is it possible the court will just simply say no need to address those issues because we are overturning the SEC's decision on the basis of the Seventh Amendment?
I think they certainly can do that. They can certainly decide one issue and leave the other two. I think they're free to decide one, two, or three. I'm not sure we can predict what they'll do, but I've heard some say that they think that the tenure protection issue is pretty straightforward in that the ALJs were found in the Lucia case to be constitutional officers. And then Free Enterprise says that the court has said 2 layers of protection is too many. And so, I think it seems clear that they have at least 2 layers of tenure protection. So we'll see how they handle that and if they find a violation there.
And maybe I should turn to Peggy then for a further elaboration on that issue of tenure protection, because in fact, one client over the years of NCLA has been a man by the name of Ray Lucia, whose case went to the Supreme Court, in which he challenged the ALJ who was before him. And the SEC said, okay, well, you won on that issue in the Supreme Court, so we'll just name a new ALJ, and you have to go through the process all over again. And I'm wondering if what you think of the treatment of Mr. Lucia by the SEC, and perhaps maybe he ought to be getting some of the benefit of the scandal that's now been uncovered about this control deficiency.
Absolutely. Mr. Lucia was particularly unfortunate in that in his case, the Solicitor General conceded that the administrative law judges had too many layers of tenure protection. So that was argued by the government, by the SEC, to the court in his case. The Supreme Court declined to reach that issue, claiming that the issue needed to percolate through the lower courts before they would reach it. But what that left Mr. Lucia with was to be sent back, given a brand new ALJ who still had concededly multiple layers of tenure protection, and he would be sent on another 6-year journey. I think by the time that Axon Cochran came around, the judges were starting to appreciate that this kind of Kafkaesque serial repeated proceedings is no way for a system of justice to operate. And that's what Justice Gorsuch meant when he said in his concurrence in the Axon Cochran case, this is what a win looks like. Michelle Cochran has to go back all over again and adjudicate these questions in a tribunal that is not even competent to decide them.
And of course, she avoided having to do that only because the scandal of the control deficiency came out later and they dropped the case against her.
Well,
Mr. Lucia done anything to try to find out whether there was a control deficiency in his case?
Yes. Both NCLA and also Jarkesy's counsel filed FOIA proceedings in district court, and we have amended that proceeding in the Texas district court because the judge seemed very interested in expediting and calling it an emergency disclosure as to those control deficiencies. But getting back to the shenanigans and the ability of the SEC to manipulate things through those, the stated reason for why they dismissed all 42 of those cases, which is unprecedented, was not only to get rid of Michelle Cochran, but anyone else who would be in a position to challenge the constitutionality of the proceedings. Now, the stated reason was, well, there was this control deficiency in excess of caution. We're going to be very careful about this. That's not the reason. And the reason it's a pretext is for several reasons. A, they only dismissed open cases. That means cases that could go to court and make the constitutional challenges. Also, they only dismissed open cases. Those very same cases could go into federal court and have discovery on what went on in the control deficiency. Our FOIA attempts have been completely fruitless. And the other reason we know they're manipulating the dockets on this is the people with open cases were not harmed by the control deficiency because none of them had an ALJ decision that was adverse to them. The people who were harmed by this widespread practice over not just 42 cases, what we believe it is many dozens more, the people who settled their cases, like Mr. Lucia, or who had an adverse decision against them, perhaps by a corrupted ALJ, those are the people harmed. And the SEC has offered no relief to those people. So we know it's a pretext because the reason they give for dismissing those 42 cases does not stand up to logical analysis.
Now, the one case, of course, that is still open, in which we know that there was control deficiency, was the Jarkesy case. So, Karen and Mike, let's just hypothetically take a worst case scenario and the Supreme Court rules against you on all of these issues, reverses the Fifth Circuit's decision, and the case gets sent back down there. Are you in a position at that point to then raise the control deficiency argument as a basis for overturning the SEC's decision?
Well, the only issues that would be before the Fifth Circuit at that point, and the answer to your question is that would be challenging without going to a district court to create a record on it, which is something that may very well end up happening. If the Supreme Court rejected all of the rulings of the Fifth Circuit and sent it back down, there are two, as Karen noted earlier, there are two other issues that the Fifth Circuit left behind because they felt they had bit off enough with the three issues that they ruled on. So there's a very serious due process constitutional challenge and an equal protection challenge to these proceedings and to the whole structure that was set up by Dodd-Frank in 2010 and the legislation in 1990, setting up the current structure. So we got two other issues, and as we pointed out to the Supreme Court last week, if the court sends it back down, then those two issues will have to be litigated in the Fifth Circuit, and we may be right back up in the Supreme Court arguing those.
Allow me to say that there was some quiet, nervous laughter on the court when they realized that Mr. Jarkesy could be back.
There are plenty of issues. You know, the system that they've set up, going back to the 1940s, with the Administrative Procedure Act, this whole system of administrative courts is really trying to jam a square peg into a round hole. The Constitution doesn't really, the system doesn't fit within our constitutional structure. And so the constitutional problems, the constitutional issues raised by this whole process are many. And we had to pare down just what we presented to the Fifth Circuit, which was 5 issues. We could have raised quite a few more as we had before the commission. And then the Fifth Circuit just took up 3, which was a lot of independent grounds on which to throw this out. And then the Supreme Court last week appeared to be only interested in 1. And it's difficult to see how they avoid the other 2 completely. There is a rational basis for avoiding the non-delegation issue if they rule for us on the 7th Amendment. How they avoid the take care clause problem with the ALJs being too far removed from presidential control, have no idea. If they leave those alone, Mr. Jarkesy, of course, gets the win because he won on those 2 issues in the Fifth Circuit.
Now, the focusing for a moment on the 7th Amendment jury trial right, which, as you mentioned, was really the principal focus of the Supreme Court during the oral argument. As I understand the 7th Amendment, it says that there is a right to a jury trial in civil cases arising under the common law, which, as I understand it, doesn't involve cases involving equity or admiralty, which under the English common law were never heard in front of juries in common law courts. And I'm wondering how that affects the right of the SEC to move forward. Obviously, if you are the SEC and you are suing somebody to try to collect damages from them, that certainly is a common law type remedy. But has the SEC always had that power since 1940 to sue people for damages, or is that a more recent invention?
Karen, want to take that?
Sure. So the SEC has had administrative authority for its regulated persons and entities. But back in 1990, it got the authority from Congress to bring any person into an administrative proceeding. It didn't use that authority very often until 2010, when Dodd-Frank gave the SEC penalty authority in its administrative proceedings. And that was the basis. The Jarkesy case was brought shortly after that, and that was the basis of our Seventh Amendment challenge. So that was a fairly new remedy that had been given to them by Congress. And I think that's where their Seventh Amendment problem came in. I do think, though, that back in 1990, and this issue had not been raised, but back in 1990, when they got the authority to bring any person into an administrative proceeding, even for equitable relief, that would have included people not regulated. And given that they had the discretion back then, I think that's where their Article 3 problem came in. And so I'm not, in the court seemed to focus that there is some difference, there is overlap, but some difference between the Seventh Amendment and the Article 3 issues. But whether they'll contend with that or how they'll contend with that is unclear. But it looks like that authority, really came into play in 2010. So
when the SEC says the sky is falling, what they mean is the sky from the last 14 years since the passage of the Dodd-Frank Act. Yeah, their enforcement authority might return to what it was before then. Do you worked at the SEC, Karen?
I would say that is such an exaggeration to say the sky is falling, because they have the discretion to bring a case in up till now, an administrative proceeding and in federal court, almost every case, they have the choice. So it's not going to change very much if they have to take all of those cases and put them in federal court. There are a handful of kinds of cases that can only be brought as an administrative proceeding. And those cases are what I would call their core regulatory authority. Like if you are a publicly traded company and you're behind on your filings and they want to deregister you, or if you no longer qualify for listing on a stock exchange, they can delist you. Those are the core regulatory things that can only be brought as administrative proceedings.
And those are not.
These other cases can be brought in federal court.
Yeah, and am I correct that those types of proceedings you were talking about don't involve the SEC trying to recover damages from an individual?
That's right.
And you were at the SEC before the passage of the Dodd-Frank Act. Do you think the SEC did a credible job back then of enforcing the securities laws, even though it didn't have the right to use administrative proceedings to get money damages?
Well, yes. I think that there was more, as I said, the authority to bring any person in an administrative proceeding did occur in 1990, but it wasn't used very often. They really still used it for the most part just to bring cases against registered persons and entities. And it was really only after they got the authority for penalties under Dodd-Frank that you saw them literally shifting their docket to the administrative proceeding realm. And there have been some cases where they will bring even people. There was an insider trading case that Peggy talked about earlier, they brought one of the defendants in federal court and the rest of them they brought as respondents in an administrative proceeding. Why they made that decision is unclear. But that was just the kind of what I would say abusive prosecutions that came after Dodd-Frank gave them that penalty authority.
And you mentioned something about Article 3, and I'm hoping that perhaps for the benefit of our audience, you can explain to me what is Article 3, what's the argument there, and how is that different from the Seventh Amendment argument?
So Article 3 courts are federal courts, and they sometimes call administrative proceedings Article 1 courts. And so the issue is, the default is that people's proceedings should go to federal court.
And where does that come from? Does Article 3 say something suggesting that there are certain types of proceedings that can only be decided by a court?
The Constitution makes allowance for the creation of federal courts. I would say that the Constitution actually doesn't mention Article 1 courts. So if you're going to go way back to the Constitution and look at it in its pure form, it's not something that is specifically provided for. The Supreme Court has allowed that and allowed Congress to create them over the years. But the SEC's administrative proceeding is an example where it traditionally brought its core regulatory actions in for people that it had a special relationship with, like a registered stockbroker or a registered investment advisor or a publicly traded company. And it has special authority over those persons and entities, and certain kinds of cases can only be brought in those administrative proceedings. And then the question became, has the court has tolerated some cases to be put into and assigned to Article 1 or administrative proceedings? The question here is, because they have this discretion, Congress gave them the right to just flip a coin, or today you put them in administrative and tomorrow you put them in federal court, whether that authority was a proper assignment to the Article 1 court. And I would argue it is not. If you look at the case law, the default is you go to a federal court unless it is properly assigned to an administrative proceeding. And so one of the, if I may, I apologize, one of the arguments that the Solicitor General made that I think was a little bit difficult to defend is that the Congress can just take away your Seventh Amendment right by putting your kind of case into an administrative proceeding and assigning it there. And I don't think that was intended by the framers.
I think it came up during oral argument that the great majority of administrative law judges who decide cases of this sort are administrative law judges employed by the Social Security Administration. Do you see a role for administrative proceedings deciding factual issues for when, for example, people are trying to get government benefits like Social Security disability benefits? Is that proper for the government to have those handled by Article 1 courts?
That sure seems to be the core regulatory authority that we were talking about earlier. And the Social Security Administration is deciding whether someone is entitled to a benefit provided by the Social Security Administration. And so I think even the court recognized early in oral argument that those kinds of benefits and those kinds of ALJs are separate, and they'd have a totally separate function than the ones that accuse people of violating the law or committing fraud and seek to impose penalties.
So that gets into the whole public rights, private rights doctrine that the court has used for over a century to help define what can be brought in an Article 1 court versus what must be preserved for adjudication in Article 3 real federal courts.
Just to sum up, am I correct in thinking that if you prevail over the SEC, which perhaps employs 3 ALJs in total, we're not throwing out the entire administrative law judge system, the great majority of these ALJs will still have jobs and will still be able to operate in the sphere of public rights. Is that correct?
Yes, I think that they were predicting, Mike, you might remember, I think there's something like 2,000 administrative law judges employed by the federal government, and it is estimated that around 400 of them carry out the kind of adjudications that the SEC had in the Jarkesy and Cochran cases.
But it's still, even with those ALJs in the FTC and other similar agencies, the number of fraud cases for penalties is still a minority, and maybe a very small minority of what they typically do. So when the government wants to adjudicate a dispute that relates to its own largesse, that relates to government benefits, government licenses, government permissions, such as immigration, such as customs,
or patents,
or military justice. There's a long history going back well before the Constitution that those are the kinds of things that are just between an individual and the government, that don't involve disputes among people, and don't involve the assessment of penalties, going after the core right of a person's private property. And so when you are adjudicating disputes between the government and a person that relate to only government benefits, government largesse, and the like, there has never been recognized a need for those things to be adjudicated in court. And many, like Social Security is the easy example of people disputing whether their benefits, whether they're getting all the benefits they think they should. There are thousands and thousands of those cases per year. They typically do not involve very much money in the overall scheme of things. And again, it's just a dispute pursuant to a statutory benefit that citizens are getting. And it's not something that pre-existed the statutory scheme. One of the ways that the Supreme Court has offered up to look at what constitutes a public right that can be litigated administratively, Article I court, versus a private right, is whether or not the underlying claim exists independently of the statute. So, for example, in Mr. Jarkesy's case, as we argued last week, the fraud claims in 10b-5, which are remarkably similar to common law fraud claims that have been litigated for centuries. Those claims exist outside of the statutory scheme in the Securities Acts, and therefore they are of the nature of private rights, whether or not they happen to be litigated with the government as one of the parties.
And I think perhaps this is a good opportunity to pivot back to Peggy and the whole issue of excess tenure protection for ALJs, because of course, Social Security ALJs, even if they are not subject to Seventh Amendment and Article III limitations, are subject to limitations with respect to their tenure protection. And I'm going to ask you what may be a very difficult question, Peggy. I think based on Supreme Court precedent, it's fairly clear that the president needs to have control over the entire executive branch, and that includes the right to not have employees who have double layers of tenure protection. But on the other hand, the Supreme Court, not long ago in a case called Collins, said if the cat is already out of the bag and there has already been a proceeding, so long as these ALJs were or these officials were properly appointed, then we're going to allow their decisions to stand. So what happens in a case like Mr. Jarkesy, the Fifth Circuit never really addressed the issue of what is the appropriate relief that ought to be given to Mr. Jarkesy, given that his ALJ had this double layer of protection. But on the other hand, if you apply the Collins decision, maybe you say, well, so what? That ALJ already issued his decision, so we're not going to go back and overturn the penalties imposed on Mr. Jarkesy just because of that double layer of protection. What's your response to that?
My response to that involves another consideration too that comes up where people often argue, well, don't you want these ALJs to have an additional layer of tenure protection because that gives them independence from the agency that they are working for, and so they might be more likely to rule in favor of the respondent before them. And my response to that factual question, and it becomes important to argue to answer your question, is it may look like that would help, but the facts show that there is an incredible structural institutional bias, and it doesn't matter whether there are 2, 3, 4, or 5 tenure protections. These ALJs statistically rule in favor of the agencies, sometimes 100% of the time, sometimes 90% of the time, but in a shocking divergence from how that dispute is typically resolved in a real federal court. So I think on the question of whether there's any benefit to additional tenure protections, that is proven wrong. Now, Collins seemed to suggest, well, what you would have to do is show that there was some sort of prejudice or harm from the ALJ having these additional tenure protections, and that's just silly. How on earth can you go back and prove a counterfactual that you went through this whole proceeding and then somehow the fact that this judge before you had double layers of tenure protection affected how he ruled in your case? You can't go back and prove a counterfactual. And this reminds me a bit of the logical silliness of the rule that required people to undergo proceedings before they could challenge their constitutionality. The concept simply doesn't make any sense. And I guess my third answer, and it's a powerful one and one I've discussed with people who've argued at the Supreme Court, is it doesn't matter whether or not somebody could show that it affected the proceedings. We are required to follow the Constitution. And the Constitution forbids these multiple layers of tenure protection. There is an independent duty for the president to take care to see that the laws are faithfully executed. And that ability, the fact that these bureaucrats are so entrenched that nobody can touch them, means that they have free rein to rule as they wish. And that is not how our Constitution was designed to operate.
Now, in the Collins case, they did find that there was improper tenure protection for the head of a very important government body that had to do with efforts to try to overcome the 2008 debt crisis. There would have been major ramifications for our economy if they had decided that every action taken by this federal agency was going to be thrown out. Do you see a distinction between that kind of case and a case where we're talking about one decision by one ALJ, so that if you overturned that particular decision, the sky would not fall?
No, and I think that and this came up in the oral argument at Jarkesy in terms of Congress has huge amounts of problems on its hands, and when you have a financial crisis, is it rational for Congress to say, well, we're going to take these cases out of the courts and assign them to these administrative proceedings? And it's just a misuse of a crisis. We see this all the time in the way the government operates. I think one president said something like, let's not let a crisis go to waste. But the fact is, the SEC was perfectly capable of prosecuting fraud in real federal courts where the judicial power is vested, and it should continue to have to do so. And will there sometimes be more cases because of the way finance and these waves of sometimes regulatory problems exist. True. But the SEC had done that for decades upon decades in federal courts. Doesn't seem to have been an undue burden upon the courts. And the cost to Americans in terms of the surrender of their constitutional due process and procedural rights is enormous.
Well, with that, I know we're about to go to audience questions, and please send in any questions that you may have, and we'll also take questions from our audience here today. But before we go to audience questions, I just want to go to each of our three excellent panelists and ask if they have any final takeaways that they want to talk about, either with respect to the Jarkesy case or the Cochran case or the scandal that we've been talking about today, where SEC was caught with its hand in the cookie jar. So Karen, why don't we begin with you?
Thank you, Rich. Mike started the oral argument by saying that the SEC's regulatory scheme is like a house that's been added onto too many times, and now it's crushing its foundation. Congress has steadily added power, and at some point it started to violate the Constitution. And so I think here, with the cases that have been brought before the Supreme Court recently, the court has been taking action to realign the agency with the Constitution. And I think more is needed. I think they do understand that you don't get due process in those administrative proceedings. And some authority has been given that exceeds the Constitution. So I think that we're on the right track in terms of realigning the agency power with the Constitution.
And I would say, sort of big picture takeaway, the founders thought that they were ratifying the Seventh Amendment mostly to protect citizens from government suits against them for penalties, attacking the core God-given right of property that's enshrined in the Constitution. And they had suffered from abuses by the British. One of the main instigators of the revolution was taxing without representation, and then enforcing the taxes in vice admiralty courts under the Stamp Act in the 1760s in order to avoid juries and penalize citizens. And there's lots of writings by the founders that we've quoted in our brief, from George Washington to John Adams to John Jay, complaining about this as one of the primary reasons for parting with the mother country. And so the history demonstrates that the main reason we have a Seventh Amendment in the Constitution, an amendment that's mainly responsible for the existence of the Constitution, is to prevent the very thing that the SEC is doing here. And therefore, there's a lot of audacity on the part of the government to come in and argue that the one time you don't get the right to trial by jury is when the government sues you to take away your property.
And Peggy, do you have any final thoughts before we turn to questions?
Sure. It's an observation I'd like to make. When I first got into this work and I saw a bunch of cases that said, well, the agency has this sort of quasi-judicial, quasi-executive, quasi-legislative power. It was like, where did the quasi-exception to the separation of powers come up? Who invented this? And it's a really bad idea. And it's just another way of describing what Mike described as the adding on to houses. And I think, bringing it back to the control deficiency, men are not angels. And when you put the prosecutor in a court where both the prosecutor and the judge are employed by the same agency, you've got to expect the temptation to share files, the temptation to share information, the temptation for ALJs to feel forced to rule in favor of their boss is simply too much to overcome. This is why they separated the powers, and in particular, the judicial power must be vested in the Article 3 courts. Congress doesn't even have that power to delegate at all. No, nothing in the Constitution gives Congress any kind of judicial power. So how can it delegate it to the executive, which is really pretty horrible because you're delegating judicial power to the prosecutor? And so if you look at it from that perspective, this muddling of powers is exactly what Mike was arguing about and briefing last week in the court. And I think that we need to return to a system where if the government seeks to prosecute you on a private right of action at which your life, liberty, or property is at stake, it must do so in an Article 3 court where solely the judicial power lies.
All right. Well, with that, let's open it up to questions. If we have questions here in our audience, or if we have questions online. Clay, go ahead.
Well, we have a question from Mark online, and the question is, what about all of the people who settled and were gagged and gave up a lot of potential claims before the SEC dismissed these other 42 cases? What can they do? And basically, can they challenge their settlements? Can they go back and say, the SEC committed fraud? They didn't tell me about this thing that they were doing. Is that a smart move for them to make? Are their lawyers going to tell them, don't do that? You're going to just open a hornet's nest. What can those people do? And aren't they really basically, screwed?
They were the ones harmed. Those very people who either were found guilty by the SEC or who settled under the impression that the SEC had a stronger case against them than they did, and there had been misconduct in their prosecution.
So Mark's question to the three of you is, what can people do about being screwed like this?
Well, there's an issue of waiver that has to be analyzed. We did, I think, argue before the court last week. You can waive the Seventh Amendment. You could waive the Sixth Amendment, the Fifth Amendment. Just about every constitutional right that's not structural or jurisdictional can be waived. And so if you didn't raise, for example, a Seventh Amendment claim during your proceeding, or take it up for circuit court review, then you've waived it, and so you're out of luck there. There is a split of opinion, including on the Supreme Court. They've got conflicting opinions on this as to whether Article 3 is waivable or not. So there's one case, the Shore case, CTFC versus Shore, where the Supreme Court held back in the 80s that a broker who had consented to a proceeding in an administrative court and had waived his right to go to Article 3, even though that's where his proceeding should have properly been. Then there's subsequent cases where the court has held that it's not waivable, and so that even though a party consented to an Article 1 court, it still had to be in an Article 3 court. So that's still up in the air. One of the things I think the Supreme Court last week was had a little anguish over is what effect this would have on previous cases, as well as what effect it will have on other agencies. And so, unlike we litigators who are just arguing for our clients' exoneration, the Supreme Court has to think of all the ramifications of its decisions. It has to do the right thing.
Clearly there is a concept of waiver that when a case has been done for enough years, you really can't dredge up something that happened decades ago. But what about the ongoing scandal of the control deficiency? If the SEC cheats in your case, should people have a right to say, oh, well, I didn't know about it at the time, so I shouldn't be held to have waived my rights to object to government cheating because I didn't know about it? Is that a valid basis for challenging?
I have a question about that. Yes, you can waive, your claims if you don't raise them, but if you don't know about them, someone could argue that their settlement was either procured by fraud or mistake. And so I think there might be an opportunity to open up settlements and challenge based upon the fact that this control deficiency, as it's politely called, was known but not disclosed to them in their settlement.
So obviously these Freedom of Information Act lawsuits that Peggy was talking about earlier could make a serious difference going forward.
If we get the information, I have lost a great deal of faith in the Freedom of Information Act, but I think Karen is absolutely right. If you don't know about a right, this would be like a Brady violation. You cannot waive it. And the same holds true, although Mike it is true, as Mike said, you can waive certain constitutional rights. One of them we maintain is not your First Amendment rights. And so the questioner online had asked about the gag. And to the extent that you are silenced on the subject of your prosecution by the SEC is just flat out unconstitutional, and they cannot force you to waive your First Amendment rights. And we are litigating that in several different courts throughout the country.
Okay, we have a question from Mr. Vecchione in the audience. Why don't you go ahead?
Yeah, I have a question for Mike, which is, it seemed to me, Kagan said that she thought that Atlas Roofing and Free Enterprise controlled this case. Is it possible that you could get a 9-0 ruling from everybody, but on widely scattered grounds?
That's a great question. There's much speculation, including by us, as to how the court's going to land on each of these issues. But concentrating on the Seventh Amendment, we could certainly see a split court with some judges agreeing with parts of this opinion and parts of that opinion, dissenting on this and agreeing on that. So I really hate to speculate what the numbers are going to be. Kind of hard to see a 9-0 decision, but we're kind of talking in circles when we're talking about whether Atlas Roofing resolves the case. We were both taking the position that Atlas Roofing in a certain way can resolve the case, and the question is, what does Atlas Roofing really mean? And has it been overturned? And so we took the position that Atlas Roofing had been long since modified, at least substantially, if not overruled by subsequent case law. And the government has taken the position that it hasn't been. The cases that have modified Atlas Roofing have been are irrelevant because it didn't involve a government action against a citizen. The problem with Atlas Roofing is it's become a Rorschach test where different people look at it and see something totally different. And so some of the justices were seeing things differently from the way we see them. So it's a sign that the precedent's not a very good one if everyone sees it differently. And so I hope that answers the question.
And just for the benefit of our audience, Atlas Roofing was a decision from about 1979 in which the court upheld the right of the Occupational Safety and Health Administration to conduct administrative hearings regarding whether particular employers were operating with unsafe conditions. And I think, Mike, you're absolutely right that exactly what that decision meant is a little bit unclear. The Solicitor General at oral argument took a very, very broad interpretation of the case and basically said that whenever we want to set up our own special tribunals to enforce federal statutes, we can. That would be certainly a very extreme interpretation of the statute. We probably have enough time for one more question, if we have any in the audience.
There's a small question online about the Supreme Court justices' discussion of Tull during the oral argument, and whether that gives some kind of a hint about which way they're going to go in public versus private, or equity versus law.
Okay, Tull was a decision from the Supreme Court that is one of them that I think Michael's referring to, that might have cut back a little bit on the Atlas Roofing decision. Mike or Karen, do you have any thoughts about the discussion of Tull and what that bodes for a decision from the court?
I think that Tull in many ways resolves the case from a Seventh Amendment standpoint. So in Tull, there were it was a government action for penalties under the Clean Water Act, and the court in that case analyzed the history and the Seventh Amendment, and came to the conclusion that if the government's coming after you for substantial penalties, you're entitled to a jury, period, whether it's a statutory action or not, and so, which that was. And the SEC has since conceded that the Tull reasoning applies fully to SEC securities fraud enforcement actions. So, but they claim that it doesn't apply under Atlas Roofing if the agency unilaterally elects to proceed in an administrative proceeding. So, and Tull even says that as well. So, the whole idea of whether the 10b-5 type actions are sufficiently analogous to common law actions in England 240 years ago is really an argument that was decided by Tull. And Tull said it doesn't even so much matter if it's a government action against a citizen for penalties. You get a Seventh Amendment right. We tried to get the court at the end of our arguments to just rule on the Seventh Amendment. The Article 3 issues were not the focus of the Fifth Circuit's decision, not the focus of our arguments. It was all about the Seventh Amendment, and getting embroiled in the whole Article 3 and the separate values underlying Article 3 jurisdiction is going to complicate their decision considerably. But Tull in many ways resolves the case.
Well, with that, I think, unfortunately, our time is up. I do want to thank our three panelists, not only for their excellent presentation today, but also for the efforts that they have been doing in the courts to battle against the SEC in support of the rights of individual citizens to have their constitutional rights protected. So I'd like to give a round of applause for our three panelists. Thank you very much.
Thank you very much.
Thanks all.